Welcome back to the courtroom, but this one is not your average dispute. Today's case, Ronald Allen versus the state of Texas, and it is a powder keg. We have secret recordings, alleged threats, attorney-client privilege on trial, but the state says his words are far more dangerous words that might place the public in fear. Did Ronald cross the line into making a terroristic threat? Or is this an overreach of justice, misinterpreting emotional speech? Stick around because what unfolds next will leave you questioning everything you know about free speech, legal ethics, and what truly defines a threat in the eyes of the law.
All right, if everyone can please whisper, we're going to go on the record. Court is calling 2025 CR 007563, State versus Ronald Allen. Could I have parties announced for the record, please?
Duffy Pitlock for the state of Texas, Your Honor.
Charles Butcher for the accused.
All right, and are you Mr. Allen?
Yes, I am.
We were here yesterday. The court heard evidence on defense's motions. The court ordered or requested that both parties be present today to make their arguments. And so defense, it is your motion. So, and both parties agreed for the hearing that they would combine the motion to suppress and the motion to dismiss. The court requested if both parties would agree to combine the motion to dismiss and the motion to suppress due to objections that both parties were having to particular evidence. And some of the objections with regards to the motion to suppress were not appropriate for a motion to suppress, but they were appropriate in the motion to dismiss. So that is why both parties agreed to combine the two motions. So with regards to the motion to suppress, what I would like to start with is we'll start with number 2, where the defense's argument is there's no probable cause. You may address that, counsel.
Judge, regarding we did hear testimony from Mr. Allen, Officer Che, and Attorney Ireland. We heard Attorney Ireland's recording. We'd seen the state's theory take its full shape. The reason we think that this lacks there's a lack of criminal conduct on this matter, because from the outset, the prosecution relied on a paraphrase quote allegedly said by Mr. Allen, which was, "If I don't get custody, I will make history and there will be dead bodies everywhere." But when we heard the recording, that phrase was never heard by the court in the recording submitted by Mr. Ireland and played for the court. The actual statement made by Ronald was, quote, "So if I was going to do that and I knew all this stuff was going to happen, period, I'm prepared for Wednesday. But something is going to happen that's going to change history, whether you bust these guys or there's dead bodies everywhere, bro."
Let's pause right here. The defense is making a bold claim that Ronald Allen was misquoted by the prosecution, and the actual audio does not include a direct personal threat. This is a major turning point, because if the original quote, "If I don't get custody, I'll make history and there'll be dead bodies," does not exist in the recording, then what we're left with is a fragmented interpretation. This raises a huge red flag. Why didn't the authorities verify the audio themselves? And how often does a paraphrase get weaponized as evidence? What do you think? Was this an honest misunderstanding or something more strategic?
Later, he says, because if they don't get busted, there's going to be dead bodies everywhere. Now, our contention is that neither of these statements includes an assertion of personal action on the part of Mr. Allen. There is no named victim. There is no identified target. And there is no expressed intent to carry out any kind of violence. It's also troubling that the DA's office or Detective Che did not fully review the audio, but simply adopted Mr. Ireland's paraphrase as fact. I think that this misstep undermines the reliability of the charging process and bolsters the necessity for judicial correction through either suppression or the dismissal.
All right, and with regards to no complainant being identified, is there really a need for a complainant to be identified if there's a threat? And I'm not saying it's a threat. These are just questions that I have, Mr. Allen. Is there a need to identify a singular person if there's an alleged threat that there will be bodies?
Well, I think a part of this is the nature of the charge is that this is a terroristic threat on a public servant. Although other public servants are discussed in the 12-minute recording that we heard, none of those public servants are specifically targeted in any of the statements that Mr. Allen made. They're talking generally about a number of things related to the legal strategy, related to the tactics that are being used. And basically, my client is speaking freely to his own lawyer.
All right, but I'm reading the indictment. Is there any objection to the court reviewing the indictment?
None from the state, Your Honor.
None here.
All right, so I'm reading the indictment, and the indictment reads that on or about April 21st, your client did threaten to commit an offense involving violence to a person, namely, and then it says to kill people with intent to place the public or a substantial group of the public in fear of serious bodily injury. So according to the indictment, it's saying a group of people and not necessarily a person who's a public servant.
Of course, Judge. We do recognize that that's what the indictment says. We accept that that's the indictment generally, but we do have issue with the idea that this statement has been taken out of context. He's not particularly naming that he's going to do anything to the court or to the courthouse or to any of the people that work here. I'm also, I think you should know, I've been practicing 15 years and I work in this courthouse every day, and I don't feel like Mr. Allen is a threat to this court either. Further, when we talk about this, Mr. Allen's testimony reflects a constitutional innocence to him because he testified that he believed he was speaking confidentially with his own lawyer. He had no intent to harm anyone. He was not emotionally stable at that point because of the difficulty that he was having with his custody matter. So he was also shocked to learn that the words that he mentioned in his own lawyer, where he has an expectation of privacy, were being recorded and being used against him to third parties.
And now we enter the gray zone: confidentiality versus public safety. Both sides agree that attorney-client communication is protected unless it involves a future crime. But what qualifies as a credible threat? The defense argues Ronald was emotionally unstable, venting to his lawyer in a moment of desperation over custody. But the state leans into the exception clause. If a threat is imminent, grave, and specific, that protection disappears. Here's the real question. Is an emotionally charged rant the same as a premeditated plan? And should your lawyer's interpretation of fear determine your criminal liability?
All right, so do both parties stipulate that a client's conversation with his attorney in a legal capacity is confidential, that that's the bar? Do both parties stipulate to that?
The state understands that confidentiality bar is there with exceptions.
Yes. All right, so do both parties stipulate?
The state stipulates.
All right, so then the next question I have of both parties, is there an exception? And I think both parties know the answer to the confidentiality if there is a threat of violence or if there is a threat of a future crime.
Yes, the state is aware.
All right, and defense, do you stipulate to that?
Yes, Judge, we do know that there are rules, Rule 105C7 of the ethics rule provide for permissive disclosure to prevent criminal acts. And we anticipate that Ireland would be arguing that he had discretion under this section if he reasonably believed that disclosure was necessary to prevent a future crime. However, according to those rules, the comments inside of those rules, comment 13 to 14 in the rules that are promulgated by the state, the magnitude, proximity, and likelihood of harm must be weighed. The threat must appear imminent and grave, and the disclosure must be no greater than necessary. The problem here is that Ireland disclosed everything and voluntarily handed over a recording, and that recording was not narrowly tailored as a warning And then we have his own testimony where Mr. Ireland gets on the stand and he tells us, also in the recording, "I'm not afraid of anything regarding this case." That contradicts a reasonable belief of a grave and imminent harm.
But counsel, wasn't his saying he's not afraid of anything about the case in reference to the pending civil case, not the alleged actions that we're here for today? I thought that's what he testified to.
Well, and I do know that what we're really talking about is that the lawyer that testified, that was this man's lawyer. He continues to try to expand and express that he's in deeper fear than he was in the moment. And I think that's a vital distinction, because if there's a terroristic threat, I think that his action should be immediate. But rather, what Mr. Ireland did, he didn't immediately call 911. He immediately called the amicus attorney. He thinks he doesn't remember that, but we believe that he called the amicus attorney because we got a bill for that. And then further, he calls the Texas Bar Hotline, which is going to favor him making this disclosure, at least to mitigate the immediate harm. But I think on retrospect, after 100 days in jail, the harm and the potential harm has been mitigated.
This moment is fascinating. The defense hits back hard, suggesting the attorney's fear was not immediate. Number 911 call, no emergency report. Instead, he called another attorney and later contacted the bar. Why does this matter? Because the timeline challenges the claim that the threat felt imminent. The attorney even admits on the stand that he wasn't afraid. Only after the fact did he change his behavior, getting off his security, firearms training, and more. Was that sincere fear kicking in, or legal strategy post-arrest? U.S. know in the comments, do you think the attorney truly felt threatened in that moment?
All right, so let's start here. The first thing is that the court finds through stipulation, and I think both parties know, that when someone is speaking to their attorney about legal matters that they've been contracted to do, that normally it's privileged. But I think both parties have also stipulated that there are exceptions to that privilege. And one of them is if there is a threat of future criminal activity, or if there's a threat of harm to anyone else. So let's start. State, do you want to address whether or not the communication that was testified, that is the basis for this alleged offense, whether or not that was privileged?
Yes, Your Honor, that was not privileged communication. It is detailed in the exception for furtherance of criminal activity, express or implied intent by saying, if X does not happen, then Y is going to happen. If X, I don't get my custody, then Y, there's going to be dead bodies everywhere. That is both express and implied. Express, dead bodies; implied, maybe the how. But this was not privileged communications between an attorney and a client. And no, the shift of the communication that you heard, the audio recording, that statement comes at like minute 10:45. I'm prepared for Wednesday, but something is going to happen that is going to change history. You bust these guys or there's dead bodies everywhere, bro. So to say that the attorney, Mr. Ireland, wasn't scared, that was at minute 4. And Your Honor was correct in assessing that that was not related to the future threat that was going to come 10 minutes later, 6 minutes later. That is not privileged communication. Those privileges are to ensure fair trial, trust between parties. The privilege is not intended to grant people a right to threaten and to use words to cause a reaction like what happened in this case. It's not privileged.
All right, so the court is going to find that there has not been a violation of the attorney-client privilege under the Disciplinary Code 1.05C7. The court is finding that the recording is not illegal, as Texas is a one-party consent state, and the attorney knew that he was recording and he was a part of the communication. There was no third party in the room. It was Mr. Allen and his attorney. Now, with regards to the warrant requirement, both parties stipulated that this was that the defendant was arrested under warrant. So there's a warrant requirement that has been met with regards to that. Now, the next thing I want to talk to you all about is whether or not the communication to his attorney that we're here for, whether or not that's protected speech. And that's a part of your motion as well, client, Mr. Butcher.
Yes, Judge. That goes towards the motion to dismiss regarding this. I think there's some particulars in the recording and in what was discussed with Mr. Ireland on the stand. There are a number of statements that Mr. Ireland stated that tend to show that at the moment, Michael Ireland was not afraid. His own words and conduct tend to prove it. First off, Mr. Ireland said, you can fire me if you want. If you think I'm not doing my job, then go ahead. I think the implication from that is that Mr. Ireland had a calm and professional demeanor and he was not in fear. Further, Mr. Ireland said, you're getting F'd. In that regard, he's aligning himself with the client emotionally and tactically. And I think that matters because he's continuing to engage in this as not somebody that's looking for a criminal intent, but he's looking for a way to align himself with his client and think about the custody case strategically and tactically. He even says, I agree with you when Mr. Allen indicates that he is concerned and afraid because of some coincidences that were happening in that litigation. Further, they even talk about subpoenaing a gentleman named Sherwood. So Mr. Ireland is strategically engaging regarding the subpoenas that he's going to issue and the work that he's going to do in furtherance of that custody case. Now, I realize that this court isn't about reviewing a custody case in any way, but what we think is that Ronald Allen's testimony reflects constitutional innocence because Mr. Allen testified that he believed he was speaking confidentially with his lawyer. He had no intent to harm anyone. He was emotionally distraught, particularly due to the custody losses, and he was shocked to learn that his words had been recorded. When we get further into this, Ronald also expresses his own fear in the recording because he says, I'm scared for my life, dude. That's not the speech of a would-be assailant. It's the language of a man trying to make sense of what he perceives as an unjust legal system. In my motion, I mentioned a number of cases that are constitutional cases, and one of them is the Watts case. In the Watts case, in a 1966 anti-draft rally in Washington, D.C., an 18-year-old draft dodger made the following remark, quote, if they ever make me carry a rifle, the first man I want to get in my sights is Lyndon Baines Johnson, LBJ. This, by the Supreme Court, was interpreted as a threat. This was interpreted as a threat by the authorities under the United States Code regarding terrorist threats toward the president. But the Supreme Court found in 1966 that they reversed the conviction, holding that Watt's statement was political rhetoric and not a true threat, and therefore it was protected speech under the First Amendment. Now, this applies because the context matters. True threats are not protected speech, but the government must prove that the speaker intended the statement to be understood as a serious expression of intent to inflict harm. So hyperbole, exaggeration, or emotional venting, even if it's crude or alarming, doesn't qualify as a true threat. Lower courts later differed on the objective versus subjective standard on this, but Watts did emphasize the importance of both context and intent. In reference to Ronald's case, this also was a vague and conditional statement. It was delivered in a nonviolent setting, and it was interpreted literally by the government, despite clear indications that it was a figurative rhetoric that Mr. Allen was engaged in.
Now this is where things get intellectual and controversial. The defense is pulling out heavyweight case law like Watts v. United States and Alonis v. United States to argue that Ronald's speech was political rhetoric, not a true threat, and they might be onto something. Courts have repeatedly ruled that vague, emotional, or conditional statements, specially made in private, are not automatically criminal. The burden is on the state to prove intent. Did Ronald intend to incite fear, or was he, like millions of frustrated people in family court, just emotionally unraveling? Would you want your vent session with your lawyer used against you?
Similarly, this case, in Ronald's case, it was emotionally charged, but it was conditional, and it was made during a private dispute involving custody. Now, Texas courts regularly apply the Watts principles. There's another case called Lopez v. State, where 631 Southwest 3D 107. In that case, the court explicitly cites the Watts case in evaluating whether a defendant's statements were true threats or protected speech. And in that case, it was held that the defendant's statements about bombing a school were not protected speech because they were specifically targeted and intended to be taken seriously. But the key takeaway on that is that Texas courts always adopt the contextual approach from Watts, looking at the surrounding circumstances, the intent, and the audience. In this case, those factors are highly in favor of a dismissal for my client. Further, there's another case called State v. Hansen, where the courts recognize that political hyperbole, even if it's violent in tone, may be protected under Watts. There's also the Dorset v. State case, where a defendant told officers, "Y'all better wear your vest because I'm going to start shooting." This was held as a true threat, but only because of the content, including a history of violence and the ongoing criminal conduct resulting in the officers responding in that case. Watts influences Texas law even without being codified. Texas courts do adopt some options of Watts because they talk about a true threat test as a conditional limitation in applying the Criminal Code 22.07. The judges are to act as gatekeepers even if the conduct appears to violate the literal text of the statute, but it must pass the Watts standard in these matters. There's another case, more recent in 2015, the Alonis v. United States case, where the Supreme Court held that punishing threats require proof of a mens rea or a subjective intent to threaten. The person cannot be convicted. The Alonis case holds that a person cannot be convicted based on how others might perceive their words. Rather, the speaker must actually intend for those words to instill fear or communicate a threat. In this case, the full transcript demonstrates Ronald's alleged threat was embedded in an extended stream of anxious, erratic speculation and emotionally charged grievances, where at one point Ronald even says, "I got called into jury duty the same week in the same courtroom. The odds of that is like me winning the lottery 20 times in a row. Bro, it didn't even happen." He further elaborates, "Hey, I had jury duty, dude. They asked me certain questions and they made me sit there all day. The same effing judge. They wanted to know what I knew and if I recognized those other two girls." When I read these statements, they don't seem to be statements of intent. They're statements of subjective fear, suspicion, and confusion. And it's exactly the kind of talk one might share only with their lawyer while trying to process whether the system is fair or rigged. So here, far from planning any violence, Ronald was exploring whether something conspiratorial was happening to him, and he was seeking his lawyer's validation and advice. In the same way in Alonis, the court emphasized that convictions under federal threat statutes require subjective intent. So the speaker must actually have intended the words to be understood as threatening. In that case, the court reversed a conviction that was based on an objective, reasonable person standard, and holding that omitting a reference to intent in a criminal statute does not mean that the mere negligence is the appropriate mental state. So here, we might agree that the words that Ronald used in his lawyer's office were negligent because they might be interpreted as a threat, but his intention, and the state hasn't shown that his intention was to make a threat
But
to the general public.
at this juncture, isn't whatever your client's intent, that's something for a jury to decide, or if this were a bench trial, then it would be for me to decide. But is that correct? That's something for the jury to decide what his intentions were. At this point, based upon your motions, what you're here for is whether or not there was a warrant issued. It's been submitted that there was a warrant issued. Both parties stipulated to that. Whether or not the communication with his attorney was privileged or not. I'm finding that the communication was not privileged because it falls under the exception of a threat that was being made. So the threat that was being made, that wasn't privileged communication. It falls underneath the exception. Now, whether or not Mr. Allen, whether or not you meant that, or whether or not it was intentionally, knowingly, or whatever the mens rea may be, that's something for a jury to make that determination. At this point, this court, I'm just making rulings upon motions that are presented to me. But there are some things that I legally am not allowed to make rulings on. One of them is determining what your mens rea is, whether it was intentionally, knowingly, recklessly, whatever it may be. And that would be what is actually in the indictment. So in the indictment, they're stating that you made a threat with the intent to place the public or a substantial group of the public in fear of serious bodily injury. So at this point, for this hearing, it is not within my jurisdiction or purview to determine whether or not you made a threat with the intent to do whatever, right? That would be something that a jury would decide. Now, if you were having a bench trial, then I would be in the place of the jury, and then I would listen to evidence and make a determination of whether or not I believe beyond a reasonable doubt that the state has met its burden based upon what's in the indictment. You understand?
Yes, ma'am.
So what I can tell both parties is that, one, there was a warrant. Both parties stipulated that a warrant was issued. Number two, the court is finding that while your communication with the attorney is confidential and private, right? But the exception to that, one of the exceptions, if there's a threat that's being made. So the communication, the court is finding the communication that you had with your attorney, the court is finding that that falls under the exception of attorney-client privilege. So, State, you want to address the defense's other points, please?
Yes, Your Honor, we would start with point number 5 in the motion to suppress, that the statement was not a true threat. The state is offering to the court and to defense what is Garcia versus State, 583 Southwest 3D 170.
Thank you.
All right, and I'm aware of the case, but I'll review it. Thank you.
I have flagged a couple important spots. The First Amendment does not protect speech like this. A true threat, and Your Honor, you will find this, I believe, on page 2, that first flagged one. True threats encompass those statements by which the speaker communicates an intent to commit an act of unlawful violence to a particular individual or group of individuals, regardless of whether the speaker actually intends to carry out the threat. And this Garcia case quotes a Supreme Court case, Black 538 US, and that's at 359. The reason that the First Amendment does not protect violent speech like this is to promote public safety and curb misdirection of resources. When defense brought up Watts, that is specific to the draft. And the gentleman in that case didn't know if he was or was not going to be drafted. So it was hypothetical, hyperbolic. In this case before the court, we heard the recording on Wednesday, 3 times, Wednesday, Wednesday, Wednesday. When the defendant talks about dead bodies everywhere happening on Wednesday, I'm gonna make history. This is not hypothetical. This is distinguishable from Watts. The defendant here is making direct threats. Now, this language is not ambiguous or exaggerated. If X, then Y. When defense says, well, look at the attorney, Mr. Ireland, he did not express fear. He did not interrupt or disengage. In the 12-minute conversation, it was 1 minute and 25 seconds after being threatened by the defendant that his attorney, his own attorney, says, get out of my office. Subsequent to that, this attorney paid for active shooter training for everyone at his office, paid for them to become familiar with guns, concealed carry, locked the doors to his office. The defendant scared this man, and that is the state's argument. This is not protected speech. It was intended to make a response. It does not matter if he intended to carry it out. The intent is to place the public in fear. It was directed to a specific date. We entered that Wednesday court date in the civil courthouse. It was it was not a joke. It was not to be taken lightly. On that same case before the court, if we may go to page 3, defense spoke of lack of mens rea. Paranoia is not a criminal element.
And here comes the knockout blow from the prosecution. The attorney's fear, the civil court's response, and the date specificity Wednesday are being used to argue that this was no emotional outburst. The state claims it was a calculated verbal bomb. And let's not ignore the optics. After the threat, the attorney changed office protocols, got security training, and locked doors. That is not normal post-meeting behavior, but is fear proof of threat, or is it proof of perception? Should the effect of your words be the same as the intent behind them? This is the ethical tightrope the jury and you must walk.
This conversation was more than exploring conspiracies against the defendant. This was not a private emotional procession or communication with the attorney. This is more than delusional, exaggerated, and distressed. It was a terroristic threat. He was not seeking knowledge. He wanted a reaction. Was it to light a fire? Who knows? But the fear was more than just at the office. It is at the courtroom. It involved the families involved in the civil proceeding. This type of language is not protected under the First Amendment. It is a true threat, and therefore defense's point number 5 should be denied as well.
All right, this is what the court is going to do. The motion to dismiss is denied. The motion to suppress is denied. I'm going to schedule this for a jury trial for September 30th. And so if there are more motions for the court to hear, please bring your motions before that date. Ms. Ferguson will make sure that it is placed on the docket.
Judge, is there any possibility
You're still muted.
that I can re-urge my motion to reduce bond
Can you hear me
Yes,
now?
there
at this time?
Yep. What's
Well,
your
not
And
name,
I'd like
please?
to ask for that
Robert
because
Well, not at this time, but if the state has no objection, we can do it later in the week.
Okay.
The state would object.
Is it for
All right.
Diane?
So
Yes.
you'll have to give them their
Okay.
10-day notice.
Is Diane with
I'm
you?
sorry,
No, my
state, how
mom
much
is
time do you need?
deceased.
You
It was
need
in your
less
mouth.
than 10
Okay.
days?
Okay.
For the reduction,
Yes.
we
And
would.
what was your first
All
name
right.
again?
So if you all
Robert,
will
right?
confer on a
Okay.
date with
Yep.
Ms. Ferguson,
Yes, Judge.
all right, and then we'll go from there, okay?
Okay.
All right, they may be able to do it sooner.
And there you have it. The judge has ruled. The motion to dismiss and suppress. Denied. A jury will now determine whether Ronald Allen's statements were constitutionally protected or a criminal act. The courtroom remains divided. Some see, others hear chilling implications of violence. This case is more than just Lutz about how we interpret language, emotion, and context. And don't forget to subscribe for more jaw-dropping courtroom breakdowns. Until next time, stay sharp.